now turn to the entree chapter, chapter 13. And we start, not surprisingly, definition of a contract. An enforceable promise that you can take to court. And you can exchange promises for promises. That's the most common thing. It can be anywhere from, if you rebuild my house, I will pay you all this money. It's a contract I'll be signing Thursday morning. We can have things that happen in the present time, and things that can happen in the future. What we're focused on is, as attorneys, we want to see our clients enter into written agreements. So that's an express written agreement. Remember that you can have express oral contracts. While as attorneys, we don't like enforcing oral contracts, the reality is that people do periodically get sued for oral contracts. Not very often, because attorneys generally don't like to fool with them. But do not be mistaken about the fact that it is possible to enforce an oral contract. It's not everybody's favorite place to go. As business people, we want you to stay completely focused on express written contracts. Now, there are also implied contracts. The activity that you do creates an impression that there is a contract there. We're going to spend a little time talking about different variations in that, but that's what we want you to think about as we get there. And frankly, oftentimes we want to avoid creating implied contracts. We want to go to express contracts. And you say, but gee, we have all this negotiation before we enter into a contract. Right. And that's why in most well-written contracts we have what's called an incorporation clause. The incorporation clause says everything that we talked about before this document is signed is of no matter. It's in here or it doesn't count. That's an incorporation clause. And again, as business people, think about it. You may have had somebody say, oh, well, we want, a 10-year warranty. Your manufacturer is going to make something for somebody. And they say, well, we want a 10-year warranty. And you say, well, our warranty is 1 year. You compromised 18 months. You have a written contract that says 18 months. 2 years after delivery, they say, well, we bought this because we got a 10-year warranty. And we say, well, read the contract. They say, well, what about all that discussion we had? Read that incorporation clause. Okay? And again, this is not about playing gotcha. Okay? This is about why we do what we do and how we do it to protect business, but to make everything as clear as possible. Remember also that most of the time you are not going to be writing contracts from scratch. You're going to be in a particular line of business or a group of businesses, and you're going to have a set of contracts that have been worked out over years and years and years. Unfortunately, that's why many of you have a 48-page cell phone contract, because everybody comes up with all sorts of weird stuff and they're developed for a national audience. So, a lot of them today say, well, if you're in California, this applies. If you're in Minnesota, this applies, and so forth. So, a lot of things that making these documents, frankly, almost useless for laymen because they're so extensively written by attorneys. That doesn't mean we shouldn't use them. It's just, unfortunately, we're kind of the victim of our own developments, and unfortunately, again, I don't mean to sound anti-attorney, I am an attorney, but unfortunately we've got a lot of attorneys out there who make a living suing businesses and making it difficult for businesses. So there's a lot of things in contracts today that are specifically out there because somebody has lost, some business has lost a lawsuit over a particular provision, so everybody rushes out to fix that hole in the contract, if you will. So that's a little bit about what we're doing here. So let's take a quick look. Elements. To be legally valid, contract must have 4 elements. An agreement in the form of valid offer, an effective acceptance, a bargain for exchange of consideration. If you want to remember just a single word, you have an agreement, you have consideration, the parties have the legal capacity to contract, and the contract is for a legal purpose. 4 parts of the contract. Certainly want to keep this slide in mind. Contract law, generally speaking, is the common law. Having said that, as business people, we are beneficiaries of the Uniform Commercial Code, which encourages trade among the states. And so because of the Uniform Commercial Code, a lot of what we talk about in business contracts is actually codified, even though the underlying basis is the common law. And remember, the 6 chapters that you read on your own at the beginning of the course explain common law versus code law. Now, we're not as concerned because of our focus on solid, written, bilateral contracts. We're not as concerned with some of the other terms, but normally what we're talking about is a bilateral contract. That's the most common thing we as business people do. In implied fact, we talked about that. We try to avoid that. You do need to know the difference. Most contracts that we're focused on, keyword, valid. We want valid contracts. Void contract, we'll explain a little bit about that. That means the contract is of no moment. More interesting is a voidable contract, and we'll explain that usually involves the concept of capacity. We care whether a contract is executory or executed. And jumping to near the later part of the course, we talk about bankruptcy. Bankruptcy is used oftentimes to avoid executory contracts. In my other business law class, we were talking about the fact most of you probably seen in the general news media, if you follow business like I do, that Sears is struggling. Well, Sears has an interesting history because it's not Sears. What happened was, as you may be familiar with, the also ran discount chain Kmart. So Kmart, as you know, is no longer in Texas. Around 2000, they went bankrupt. Well, what they did is they went into reorganization. They went into a Chapter 11 bankruptcy, and they looked at every location where they were not making money. Most of their locations were leaseholds. Those are executory contracts. You say, well, gee, they're leases. Yeah, leases are contracts, special form of contract. So what they did is they went through and they identified all their losing locations and says, we need permission from the bankruptcy court to avoid all those leases. And they dropped out of Texas entirely. So that's why you see some of these old, large, big box buildings that have been converted. There's one not too far from here, 18th and TC Jester's, a big restaurant supply store there. That used to be a pretty large Kmart. There's a couple others around. A lot of them converted to flea markets and stuff like that. Buildings are still standing, but they've been repurposed and divided into other structures. In any event, what happens is, because they're executory, they have not been performed yet, bankruptcy court, just by stroke of the pen, wipes all those leases out. Now, there's a very bad downside to that. Suppose you're the landlord. Well, you got your property back, you can lease it to somebody else, but a lot of times you were counting on that 10 or 20-year lease with Kmart to be an anchor to bring other small businesses to remain in the shopping center. And it's not so easy in a down market to fill a space like that. Of course, Walmart, generally speaking, is not going to come in and buy an old Kmart location. They're going to come in and build their stores from scratch. They've got their own designs. And frankly, the Walmarts that we're seeing built today are much larger than the Kmart stores that would be the competitors in past generations. So to tell you how weird this deal is, while Kmart is in reorganization bankruptcy, a French bank agrees to loan them $2 billion. Now, if I go bankrupt, I'd sure like somebody to loan me $2 billion. Okay, yeah, somebody knew what was going on here, right? Because they're saying, well, gee, they're going to wipe out all the losers. They're going to come out of bankruptcy. They're going to be ripping, and they're going to, only have to worry about the good ones, the good locations. So in any event, Kmart comes out of bankruptcy, rocking and rolling, and it next buys Sears and changes the name of Kmart to Sears Holding. Wolf in sheep's clothing. Still Kmart. And we know that because they're in trouble again right now, and they have been for about 2 years. And I'm not saying anything out of school, it's in the national press. They're one of the 10 companies, 10 common names of businesses that are in trouble this year. There's several articles out, toward the end of the business year, the calendar year. There's a number of articles out talking about, very popular, well-known names that may not make it, much further. Sears is very high on that list. To give you an idea, another name on that list is BlackBerry. And somebody in one of my classes did a check and said BlackBerry is down to 0.8% of the total smartphone market. And they were the only smartphone roughly 10 years ago. The only smartphone. So how just part of the nature of competition. So anyway, some interesting things to think about. That's an executory contract. It's a lease. It's not yet been performed. Bilateral exchange of promises that are mutually binding. Now, we're not very worried about unilateral contract. Unilateral contract is basically if you do something and then you do it, well, okay, you did it, yeah, I'll pay you. But there's no formal acceptance. So it's not a promise for a promise. It's a promise, and then the person is paid or whatever they wanted to get given despite the absence of a formal agreement. Obviously, as business people, generally speaking, we're not going to do that very often unless you say own a retail store and somebody comes up and sweeps the parking lot and says, would you give me $10 since I just swept your parking lot? Performed by action. And that's, again, pretty sloppy, and you're generally going to negotiate that deal up front. Most people would. So again, we talk about express contracts. And what we're trying to avoid is the second bullet is implied contracts. We really want things to be solid as business people, so we want express contracts overwhelmingly over implied based on what people are doing. Now, a classic example of implied, however, is a retail store. So speaking of Sears, so we go to the Sears store that's a few blocks from here, and we walk in and we grab a handful of stuff and we walk out. Is that going to work? Probably not going to make it to our car without being arrested. Yes. What happened? We didn't have a contract. It's implied by normal custom that when you go to a retail store, even though you don't sign a contract on your way in the door saying, I will pay for whatever I take while I'm in here, it's implied in fact. So don't leave the store without paying. Don't say Dr. Shine said there was no contract, it won't work. You'll go to jail. I won't bail you out, I don't do criminal law. The best I'll do is, well, this really happened in the middle of the summer. I get a call at about 11 o'clock at night, and an air conditioning company that I'm consulting for calls me up and says, Jimmy Bob's in jail for drunk driving, and unfortunately we need him, it's summertime, we need every AC tech on the job, so we need him out of the Huskow as soon as we can. And I said, I said, are you going to pay the bail bond? He said, yeah, we'll pay for it. I said, okay, let me get your information. So I didn't leave the couch. I just called the bail bond company and said, hey, I'm an attorney. We need to get Jimmy Bob out. They said, well, give us his information. What jail is he in? He's downtown Freezer Street. And I was like, okay, all right, here's who's paying for it. And they said, okay, we took his information. So I didn't pay for it. I just made the client pay directly. So what happens is people sometimes think, okay, I'll run down and post bail and I'll get, Tiffany or Jimmy Bob out of jail. It doesn't happen that way. They can't leave until they've been arraigned. And generally speaking, the judges may or may not be there overnight. Big city like Houston, they may be there overnight. But a lot of times, on purpose, they leave them in a cell overnight to make sure they understand the severity of the entertainment they're about to exhibit. And so what happens is that they then get out in the morning, they have a hearing and their bond will be set at personal recognizance, in which case they don't need a bond, or it'll be set at a certain amount of money. Well, if it's more money than you have, the bail bonds companies come in and they get, say, 10% of the action. So if you have a fairly serious DWI, you may have a $5,000 bond. You give the bonding company $500, they post a bond of $5,000. And I know most of you probably heard of that TV show, Dog Bounty Hunter. Well, that's what, if you don't show up for your court date, they go looking for you because if they deliver you to the courthouse, then they get their $5,000 back. But most people do show up because oftentimes family members are the ones who sign the contract and put the money up, and you don't want grandma to go to jail because you didn't show up for your court date. So usually people generally tend to show up for their court date. Not always, otherwise you wouldn't have a TV show like Dog the Bounty Hunter. So in any event. One of the reasons that you have to pay for things is because of the concept, and it's in italics in this slide, called quantum meruit. How's that for an interesting sounding word? You will probably in your whole life only hear it in this part of this course. We might mention a couple of times. Basically, it is an equitable doctrine. Remember we talked about law and equity in our introductory chapters that you read. Law is about money, equity is about doing the right thing. And today, in modern societies, we generally don't separate law and equity. In fact, we say we have courts of law and equity. We try and do right. Equity would be an injunction or declaratory judgment about something. Law is how much money did you lose, what do we need to pay to bring you whole or to make things right. So quantum meruit is an equitable theory that says that you derive some value. So you go to a hotel room, you spend the night in a hotel room. Of course, in a modern hotel room today, you actually sign a contract. You may not realize it if you booked your hotel room on Hotwire or Orbitz or whatever, but you were entering in and you click some boxes there. You click through, you have entered into a contract even if you paid through there. But when you go, most hotels today are pretty careful. I know when I travel, most hotels, if it's international, they want to see your passport. If it's domestic, they want to see your driver's license. A lot of them have a form we have to fill in, provide your license plate number of your car and rental car, stuff like that. So there is definitely something going on, but if for some reason you are able to gain some value, say while you're staying at the hotel, you go down and you eat in the dining room and you don't pay. You just say, well, gee, there's no contract here. I don't remember signing anything at the front desk that said if I eat the food, I'm going to have to pay for it. Well, of course, if you're staying at a hotel with a free breakfast, that's not an issue. But let's say you don't, you go to a place where you're expected to pay, you walk the tap. Well, they figure out you're in room 628. They can bill you for that because you have derived a value even if in the absence of the contract. So that's where quantum meruit factors in. How about enforcing that contract? It's no fun to have a contract if you can't enforce it. So the first one is enforceable. That's what we want as business people. We want to make sure it complies with the 4 branches that we talked about, the 4 key aspects of the contract. We're going to make sure that's happening. It's unenforceable. You can't recover on it. You can't get there from here. A good example here in Texas would be a void contract. If you enter into a gambling agreement. You say, you know, I'm betting on the Texans to beat Denver on Monday night. Yeah, right. Yeah, that's about right. Yeah, I think 27-9 was the final score last night. Three field goals. I think in the last 3 road games, they've scored 1 touchdown. Last 8.
They're like 6 first downs too.
Yeah, yeah. Well, the worst part was, the only part of it that I saw was on the news clip where, oh, I know what's new, and I was flipping channels. I get to watch TV like between 11 p.m. and 1 a.m. So I'm flipping channels, and they show the quarterback for the Texans, and the ball trails off, and then the issue was his arm in motion or was it a fumble? And of course, he made no effort to recover it, so he at least was smart enough to know, I'll pretend that I was in motion and it wasn't a fumble. Well, the ruling on the field stands as a fumble, and it's pretty clear that it fell off the back of his hand back here. Strange deal. In any event, if you're gambling on that game and you've got a friend of yours who's stupid enough to bet you $500 that the Texans would win, If he doesn't pay up, you cannot take him to court, because that would be an illegal gambling contract. It's a contract, but it's unenforceable because it's void, because you are lacking a key element, which is the legality of the agreement. Now, voidable is very interesting. We're going to talk about it here, but we'll remind you of this as we go through some of the other chapters. And that is, we often use the example of Justin Bieber, who became an internet sensation and then became a performing sensation, and now has slunk off into near oblivion, as he should have from the beginning. And so, yeah, in any event, the thing about Beeb is, okay, so he's 15 or 16 years old. He's out there doing recording contracts and concerts and all that. So here's the scenario. The Beeb and his entourage show up at the Four Seasons Hotel, and they say, you know, we need 7 rooms. You know, it's me and my 6 buddies here, and we all want our own nice room. So, you know, $500 a night. And they say, okay, and they let him sign it. But he's only 16. So the next morning he checks out and moves to the next destination, and they say, well, you know, it's $20,000 between the rooms and room service, and you know, those bottles of Blue Clicquot and Moet are expensive. So what happens is that he then says, I'm a minor. I do not have the capacity, because I took Dr. Shine's business law course, and so I'm not going to pay. Well, the first answer is correct. To the extent that a minor entered into a contract, they can enforce it, but the adult, if you will, or the business cannot enforce it against the minor. Remember our friend Quantum Merowith, however. Quantum Merowith applies here. He derived a value of basic boarding and food. Now, because it is not legal to sell alcohol to minors, the booze would probably come off the bill right off the top. So you just cut $10,000 off the $20,000 bill when the champagne comes off, unless you can attach it to one of the adults in his entourage, which is the way I would do it. Then the second part is, what was the reasonable value of food and board provided to him? So you say, well, it's $500 a night hotel room. It's a pretty nice hotel room. What was it worth? Maybe $100 a night. So they can recover the fair value, may not be the value they were hoping to recover. Same for the food. Now, we all know room service is a very, very expensive way to eat. The court may say, well, we'll give you whatever it would have cost to buy the same food at Denny's, but we're not going to give you, you know, the thousands of dollars that you got billed on the food service. So part of the point here is, again, the minor doesn't walk off scot-free if what's provided provides food and shelter or other necessaries like emergency medical care. If he conks out on stage, or occasionally performers walk off the stage and get hurt in front of the audience and stuff like that. I'm trying to think who did that recently. Walked right off the stage, really hurt themselves pretty good. I think somebody had a heart attack the other day. It's real interesting stuff. Sometimes fatal, sometimes not. Hopefully not fatal. We talked about executory and executed contracts already. Now, we want to talk about damages. If you have breached a contract, you want to get something out of it, right? That's reasonable. So what we have is we have nominal damages. Going back to sports and football, one of the most famous nominal damage cases in history was the World Football League versus the National Football League and the major TV stations, the major TVs and sports networks. The theory is that the World Football League failed because it was a conspiracy between the NFL and the major sports broadcasting networks to freeze them out. And that conspiracy was what caused them to fail. The jury, having heard all the evidence, awards $1, and they were suing for tens of millions of dollars. Well, basically, what that means is the jury said, yeah, there was a conspiracy, but the problem is you weren't going to make it anyway. So since you weren't going to make it anyway, to say that the failure of the football league is all on their shoulders didn't compute for that jury. So that's probably one of the best known cases of nominal damages. Now, compensatory damages are pretty straightforward. This is what we're generally focused on. This is if you, lost the income from something, if you have an injury and you can't go to work, if you have medical bills because you were injured. These are compensatory damages. This is to put you right. Now, consequential damages are a little bit more complicated. Many business contracts exclude consequential damages. They start by defining consequential damages, and then they exclude them. And this is basically, okay, we breached our contract to buy pumps from you. So you're supposed to make 6 custom pumps. All we're going to do is give you the metal that you bought for those 6 pumps. We're not going to give you any lost profit because that's consequential damages. But we'll give you compensatory damages, meaning the value of the steel that you have in your shop in order to use those pumps, only if you can't use that steel to make pumps for somebody else. So it's a pretty stingy deal. And a lot of big companies enter into these contracts where they exclude all the consequential damages, which, think about this, you're a small machine shop, you make stuff for the oil field. You set aside capacity, you hire machinists, you may even buy new machinery to make sure you can get the products made on time. And then the big company says, never mind. The only thing you get back is your steel. How about those new equipment, all those new employees? No consequential damages. Not directly related as part of the contract. I say, why, as business people, need to understand what's happening in the contract? Because you're on the front line. Your attorney may or may not be there, generally not. Generally, attorney's someplace else, and you email them the contract to them and say, hey, what do you think about this? But you're the person sitting in the room negotiating, or on the phone, or Skyping, or however you're communicating. Punitive damages. When you hear about tort reform, most of tort reform is focused on punitive damages. Famous case from Texas, out there in our friends in Brazoria County. A bug company goes out and sprays a staple, kill the fleas or whatever the problem was out in the stable. The cow drops dead. So the cow goes from being a $600 cow to the world's best prize cow. They sue the exterminating company, and the award is $8 million. $1 million for Bessie the cow, and $7 million in punitive damages. Why, we're still not sure. This decision in the late 1980s is upheld by the last Democrat Party dominated Texas Supreme Court. The next election cycle, the Texas Supreme Court starts to go from 100% Democrat to, by 1991 or so, 100% Republican. So while some clown out there got $8 million, a lot of people got unelected because Texas has political election of judges, by the way. That's not true state to state. We're focused on teaching this course nationally, but we want you to see a great example of why there's tort reform. Tort reform says the actual damages have to bear some relationship to the actual value of the animal. In this case, it might have been $600,000. And then the punitive damages are possible, but they need to bear some relationship to the actual damages, which means they might have gotten $5,000 punitive damages if they got $1,000 for the cow. It's usually a proportion of the actual damages. Putting this in human terms, you're in a big car accident. You have medical bills and all that. A lot of attorneys today use a benchmark of 1 or 2 times your medical bills to determine your pain and suffering. Pain and suffering hard to quantify, so we use medical bills as a proxy. So if you have 100,000 medical bills, we'll say that you have 200,000 in pain and suffering. The court might let you have that. But Texas has implemented tort reform, but that's what we're talking about, creating a system where there's some sense about it. You say, well, why do I care? Gee, if I'm in a car accident, I'd like to get all that money. Well, the problem is, good Lord willing, you're not going to be in a car accident, certainly not in one where your car rolls over 6 times and you have one of these horrible dramatic accidents which we see in the news. But you pay every single day when you get your insurance bill. In fact, my insurance bill, my renewal for my 2 automobiles, I have 0 accidents, 0 tickets, and my for my 2 old vehicles, the insurance increase was stunning. I mean, just stunning. So I go to my insurance agent and I say, what's happening? And he said, well, remember you're paying for everybody else. And he also said because of the floods, remember the bad floods we had last year, not this year's floods, last year's flood, a lot of cars were lost and the insurance companies were still paying for them. So we're all paying for the cars, from the idiots who drove into 6 feet of water and were just surprised that the car didn't work like Get Smart with little propellers on the bottom or whatever. So in any event, that's a little bit about what happens here. Now, liquidated damages is almost purely a contractual situation. And what this is, it's a very common employment contract. It says, we've put in a non-compete clause. And if you rip us off and you compete against us, we're going to take anything we haven't paid you yet that we still owe you, and we're going to assess you 2 months of income as the minimum penalty you'll pay for ripping us off and violating your employment contract. Now, it is very, very hard in Texas to enforce employment contracts. Employment restrictions like this are not even possible in California. In contrast, I also practice in Virginia. Non-compete contracts are fully enforceable in Virginia. So you got 3 different views. Enforceable in Virginia, maybe not enforceable in Texas, not even possible in California. Point to the story, you need to know, as business people, we work across a lot of different states. You need to know the law of each state where you do business and the nuances associated with that. Yes, sir?
Are liquidated damages a substitute for compensatory damages?
They generally are not considered the same definition because compensatory would require proving up what they lost. They're saying they're a substitute way of calculating compensatory damages, and they're usually worded as minimum. Like, we might prove we lost $500,000, but by golly, at a minimum, we're going to get the $22,000 that you made your last 2 months there. So usually, and by the way, judges hate liquidated damages clauses. Why do you think that? Because judges are egomaniacs and they don't like the parties taking the law into their own hands and volunteering a way of calculating damages. They want to be able to do that themselves. But yeah, judges really work to get out of liquidated damages clauses because they don't like it because of that. We talked about equitable remedies. Another equitable remedy other than quantum meruit is specific performance. Specific performance is a very limited remedy. It has to be a unique situation. The best known example of specific performance is real estate, because even though you may be out in a tract subdivision where there are 400 identical houses, each one of them sits on a unique piece of real estate. So each one of them, if you say, you know, I have a contract on lot 28, and the builder comes to you and says, you know what, you did have a contract, but we just sold lot 28 to somebody else. We're going to give you lot 29, and it's identical. You can say, no, I insist on lot 28. I'm going to invoke my equitable remedy specific performance. 2 other applications for it are items that are unique. A Van Gogh painting. You know, you win at an auction, you're supposed to get this beautiful Van Gogh painting. They come up and say, well, you know, we've got this other famous artist, and we're giving this painting instead. It doesn't work that way. Specific performance. So antiques, rare pieces of art, and real estate. Things that cannot be replicated with money.
You can, in regards to the specific performance, is that sort of like the whole Volkswagen issue today with the turbo diesel cars? Where they're saying it performs one way, but it was totally done the other way. They lied about it. As a consumer of a Volkswagen, could you go on the basis of specific performance?
I don't think I'd use specific performance in that particular application. I would just use straight fraud. In other words, they made representations about their car. They were not true. You relied on them to buy your car, either in terms of its gas mileage or its compliance with U.S. safety regulations and environmental regulations, and therefore you were duped and you were the victim of fraud. And that's most likely the argument that will be made. And I know there's some lawsuits coming up. Although the biggest problem that they have in the Volkswagen case is a very ugly one. I know people are not going to like me for saying this. The reality is, you were probably, first of all, I have one of my 2 old vehicles is a diesel. I get the $7 inspection. I drive in, they said, yep, it's a diesel, we can hear it, boop, 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 boop. There's no regs. So unless you're in California, most of the states, maybe Massachusetts, but California has very heavy regulations, including on diesels. Most of the states, you were never tested. Nobody cared whether the thing fooled the detector or not, because most of us never had the cars checked. The other thing is that while there are a lot of Volkswagen diesels made, there really aren't that many on the road, because gas prices have been modest for a long period of time. Volkswagen are generally pretty economical cars. I really think the fines that they're paying are bigger than what the consumer damage will ever be, because the government's really mad at them because they were tricking the government. But it's not going to, I don't think it's going to be a big civil case, because you're going to have to show you actually had some damage. Now here's where your damages are going to be. Because of the adverse publicity, you might argue that my $20,000 diesel Volkswagen Passat, I don't even know if that's the right model, will only sell for $8,000 as a used car. I think after this whole thing blows over, if it was going to sell for $10,000 and it's only selling for $8,000, a couple years from now it'll blow over. So you're going to have to, it's not going to be an easy sell to show that there was this huge loss in value. Again, because the consumer, pardon the sexist term, the man on the street doesn't care that it fooled the testing in a couple states that require diesel testing. If it had been a gas vehicle, definitely a much, much larger case and much better consumer case. Just the nature of the beast. And I'm a bit of an old car buff, so that's why I know a little bit more about it. But very good question. 2 other terms I want you to take away from here: rescission and restitution. Rescission, we want to put the people back where they started in a contract situation. Or restitution, if you've spent some money on the deal doesn't go, can we give you enough money to put you back sort of where you were?